have a question that's super relevant, and we covered this in the first show, but I think it's something that is worth covering again. So Josh writes here, have you ever heard of trying to get an attorney investigated through a bar of ethics or whatever it's called? And I'll kind of stop there because he kind of winds around.
Wait, put that back up so I can read it.
Okay.
Criminal offense with the child's mother having an order that's been falsified against the father. Have you heard of them just blatantly ignoring the complaint against the attorney? No.
So
I don't really completely understand that question, but no.
I want to tie it back into something very specific though, and that is bar complaints. And family law attorneys in general are some of the most complained about attorneys. It's I think it's number two.
No,
I don't know.
number one.
It's
Well,
probably number one.
I think family law attorneys and criminal defense attorneys sort of trade places, but I think it's consistently recently been family law attorneys. It's interesting because a very good friend of mine is a lawyer's malpractice insurance broker. So she spent a decade writing lawyers' malpractice policies for lawyers. So I've read all of these insurance industry insider documents about what you look for when you're insuring an attorney. But anyway, so go ahead.
So when there's a bar complaint, and it's you're trying to get something remedied, you're trying to get something investigated. The number one thing is the attorney has to have actually violated an ethical rule. You being unhappy or you not liking the outcome is not enough to trigger an investigation. That's a situation where they may call the attorney up and say, "Hey, what happened?" And it'd be, "Hey, I fired the client because they weren't paying and they violated our agreement," and they'll close the file. So if you're having issues with an attorney, what are some things that how do you want to structure, or what do you want to do to end up with a bar complaint that is actually taken seriously?
Okay, so the first thing that you have to do is that you have to understand thoroughly the rules. Here's my copy, okay, and it's beat up. And without understanding the rules, you can the rules are somewhat intuitive. They're really intuitive. So a person who feels like they're seeing that opposing counsel is doing stuff that feels wrong, that's probably a sort of a good gut level indicator that you're probably right. They probably are doing something that's wrong. Okay. And in my case, the very first indicator that I got about it was when opposing counsel was saying XYZ happened when I knew for a fact XYZ never happened. So that meant she either was A, flat out lying, which I don't doubt. She's a lying sack of shit. Okay. That's what she does. I know that now, but at the time I didn't. Okay. So she was either flat out lying, or B, she hadn't investigated, okay, adequately. Because if she had investigated adequately, she would have been able to determine fairly quickly and fairly easily that what she then later said, which wasn't true, actually wasn't true. So one of those two things, she knew she was lying up front and she was flat out lying because it was advancing her case, and there's a lot of that, or B, she just didn't investigate. But both of those things are unethical. Both of those things are unethical. So, it can feel wrong, right? You just feel like that's wrong. Well, then the first thing that you want to do is you want to go to unethicalkarma.com, right? And you want to look at the page that has every single jurisdiction in the United States, including DC and Guam and whatever else. And you want to go and you want to download the rules of professional conduct for that state, and you want to read them. You want to read them 2 or 3 times, and you want to print them out, not just have them on your computer. You want to print them out so that they're on your desk and that you can read them and you understand them, so that when you are ultimately writing a bar complaint, what you are doing is you're saying, Sean violated ethical rule 1, 2, 3 when he did XYZ on this date. Okay? And here's the evidence of what it is that he did on that date. All right? Therefore, he violated the ethical rule. It needs to be that clear. The one that we see a lot, or that I saw a lot, and I'm still seeing a lot of in family law, is lying to the court. Lying to the court, not adequately investigating claims. I guarantee you, every single bar, every single jurisdiction, their rules of professional conduct have a rule that basically says that all issues have to be well grounded in fact and law. So it's the ethical rule equivalent of the civil procedure rule that requires that everything is well grounded in fact and law. And now that I'm, of course, under pressure and got a camera in front of my face, it's slipping my mind what one it is, right? Because I'd love to be able to just read from it. But that's the one that requires, that's an ethical duty for an attorney to adequately investigate. RPC 3.3, which is candor towards the tribunal, it says very, very clearly. I mean, it doesn't get much more explicit than that. It's clearer than, say, the Second Amendment is. Right? Okay. A lawyer shall not knowingly make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to a tribunal by the lawyer. That's pretty damn clear. And you know what it doesn't say? It doesn't say a lawyer shall not, except for family law lawyers.
So I think the big takeaway there is understanding that just being unhappy or not liking something isn't enough. What ethical rule did they violate?
You have to know that very clearly. In law school, we go to law school and, we learn, all right, all of us learn this very formulaic way of legal writing, all right? You'll remember this: issue, rule, application, conclusion, right? Every single piece of legal writing, from a Supreme Court case to a motion in a trial court, follows that format. What is the issue? What is the rule? How are the facts applied to the rule? All right. And what is the outcome? As it relates to a bar complaint, it's the exact same form of legal writing. All right. And what it is lawyer Smith violated ethical rule 3.3 when lawyer Smith lied to the court saying that Sean was at his ex-wife's place of work trying to talk to his ex-wife, when in reality Sean was sitting in his office 5 miles away talking to his office building manager. So that's the statement. Lawyer Smith knows that they violated the ethical rule because Sean served on lawyer Smith on a day before lawyer Smith made their statement to the court the following documents that prove that Sean was not downtown Seattle, was instead in his office. Despite knowing that these facts, lawyer Smith then told the judge in the motion on this date that Sean was downtown Seattle, when in reality he was in his office. See the court's official transcript. It needs to be that explicit. And here's why. So the standard of discipline in lawyer professional discipline, okay, is, and I'm reading right now from a Washington State Supreme Court decision. All right, the standard of the acts of misconduct in bar discipline cases must be established by disciplinary counsel. That means the bar association, by a clear preponderance of the evidence. This standard of proof is somewhat lower than the beyond reasonable doubt standard required in criminal prosecutions. So it's a little bit lower than beyond a reasonable doubt standard. All right. And there's another case. All right. A clear preponderance of the evidence is an intermediate standard between simple preponderance in a civil suit and reasonable doubt in a criminal action. So that means that you've got to give the Bar Association clear evidence, right, of misconduct. Or at the very least, you have to give them enough evidence to show that there's a very serious problem that they then investigate, because they then may find additional evidence themselves.
I think that's a big point.
Yeah, and
you have to give them evidence. You have to give them something to say, we're going to expend resources to look into this matter. You can't expect them to do all the work.
Right. It can't just be, I know because I feel it in my gut that, Lawyer Smith lied, right? When he said that I was a domestic violence abuser, because it never happened, right? The thing that the unethical attorneys who create these conflicts hide behind is that they are allowed to believe their client. So they're allowed to presume their client is telling them the truth. Well, the problem for that becomes is that that's true, but it's only true to a certain extent, because the ethical rule that requires that they do conduct a reasonable investigation, right? Once they've got constructive knowledge, once they've got pretty good information that their client is lying to them, their ethical responsibility is in order to investigate what the truth of what their client's saying goes up, right? But they all just conveniently ignore that. There's like, well, that's just not what we're going to pay attention to, because if they did that, then they would very quickly find themselves in a situation where they'd have to talk to their clients and say, look, I'm not going to lie for you. And, you're saying things that are false, that are provably false. And I'm not going to lie for you, because if I lie for you, right, I could be disbarred because of that. And so that means that, you're either going to have to fall on the sword and authorize me to go forward and correct that, right? Whatever false statement that I just put before the court, you're going to have to authorize me to correct that, or I'm going to have to withdraw from your case, because I can't be a part of that. But they don't do that, right? Because that doesn't continue to generate $425 an hour. And they also know, many of them also know, and for instance, opposing counsel in my case knows very, very clearly that that when my ex-wife goes and consults with another attorney, a capable, knowledgeable, ethical family law attorney, they're going to say to my ex-wife, your attorney fucked your case up really badly and put you in a place that's just, really, really bad. And you've got these, huge problems now because of the way your attorney managed your case. And I know that not just because of my experience in this case with opposing counsel, but I know that because I've also read that in, the docket filings of other attorneys, and I've spoken with other attorneys who've got experience with this particular bad apple. And they've come back and said, this is what happened.
Yeah, I think that brings up a couple really, really good points. I mean, I think your point about individuals going to another attorney and their attorney leveraging that into business for themselves, I found that, I'll be honest, I fired more clients than have fired me. But every single client that has fired me, it has been around them demanding I do something that I just say I can't do that because it's either not true, we're stepping into an ethical gray area, and a couple days later I get a fax, I get an email, I get a packet in the mail with a substitution of attorney form on it. And so it ends up being, I think, this catch-22 for an attorney, especially maybe an attorney who is struggling to get by financially, which I know for a lot of our viewers is sacrilegious to say, but there are a lot of attorneys, especially in family law, that do just enough to get by. And so the question becomes for them, do I step into this ethical gray area and make a little bit more money, or do I run the risk of them running to my competitor down the street and them saying, oh, he messed up or she messed up, come work with me, we'll fix it. And then obviously there are the attorneys who are part of massive money-making firms, and they'll do anything for that, like you said, that $425 an hour.